Right, the next two cases have been consolidated for argument purposes, and that's Wright versus Service Employees International Union Local 503 and Zielinski versus Service Employees International Union Local 503.
Yes, thank you, Your Honor. May it please the court. My name is Rebecca Millard. I represent the appellants, Christopher Zielinski and Jody Wright. I would like to reserve 2 minutes for rebuttal, if I may.
All right.
After listening to all the arguments this morning, it appears to me that asked me Counsel 31 back in the Janus case, they should have just forged Mark Janus's signature. They would have gotten more of his money if they had done that. And better still, for the union, had they done so and the courts followed the reasoning below, there would be no constitutional issue. The state can just shrug out of its constitutional duties altogether. But when it comes to states taking public employees' lawfully earned wages for union dues, the Supreme Court has always held that the employee must consent before the state takes that money. And that has been true from Abood through Janus and is still true today. Mr. Zielinski and Ms. Wright never became union members. They never consented to the state taking their wages or taking union dues out of their wages, yet the state took full union dues. The union's excuse here? A forged membership card. I would like to share my screen just very briefly, if I may, and show you a copy of the membership card that SEIU 503 used to justify deduction of dues from Mr. Zielinski. As you can see, the signature is a series of connected M's.
Screen sharing.
Thank you. The appellants seek reversal here for 3 reasons. First, it violates the First Amendment's prohibition on compelled speech for the state to take the employee's money for union dues for political speech purposes without the employee's consent or authorization. Second, there is state action when SEIU uses the state to forcibly take employees' money, just as there was state action in the Janus case. And third, this case presents a live controversy because Mr. Zielinski and Ms. Wright are still waiting for a refund of their dues. The state still uses the exact same procedures, and because declaratory and injunctive relief would effectively prevent recurrence. As to the first, Your Honor, the state system here gives the union sole control over who authorizes and who does not authorize union dues. And that results in people paying when they haven't consented. The system is essentially rigged against the employee. Again, Mr. Zielinski and Ms. Wright should not have had to pay anything. They never became members. But unions don't even need a forced fee scheme anymore. They have something better, a state law that puts the union in sole control. And then if anyone complains, they produce a membership card and claim the dues were authorized from the beginning, which is exactly what is happening in Oregon.